Namaste, I am Hemanth, and today we are going to be dealing with the topic of Limitation Act of 1963. The principle behind the Limitation Act of 1963 are: number one, interest republicae ut sit finis litium, which translates to in the interest of the state, and there should be a limit to litigation. The second one is vigilantibus non dormitibus iuris subvenienta, which translates to the law which assesses only those who are vigilant with their rights and not for those who sleep upon it. The Limitation Act 1908 was repealed by the Third Law Commission and the Limitation Act of 1963 came into force. Meaning of Limitation Act. The Limitation Act of 1963 prescribes the time limits within the legal actions or proceedings which can be initiated or brought before a court. It sets a time frame within which a legal remedy must be sought, starting from the occurrence of an event that gives rise to a cause of action. For example, the limitation bar on the debt recovery is 3 years. So, if a person who has lent money has to file a suit for recovery of the amount, he has to do so within 3 years. For better understanding, let's take an illustration. Abhinandan takes a loan of 50,000 rupees from Varun. Abhinandan then refuses to pay. Now, Varun has to sue Abhinandan, if he wants to, within 3 years from the date he lent money. The Limitation Act varies depending on the facts of the case and circumstances. For the immovable property, the time bar is different. For the contract, it is different. So on, so forth. Why is the Limitation Act needed? The Limitation Act in India is crucial for securing legal conclusiveness, averting the submission of outdated claims, upholding fairness and efficiency, and fostering prompt resolution of legal disputes. It also reduces burden on the court. Conclusion. There are certain exceptions of the Limitation Act, so please do consult an advocate for better opinion. This is Hemanth and you are watching LawQuest.